The Cumberland Compact. The freemen of this country over the age of 21 years shall immediately, or as soon as be convenient, proceed to elect and choose 12 conscientious and deserving persons from or out of the different stations. That is to say, from Nashboro, 3, from Jaspers, 2, Bledsoe, 1, Ashers, 1, Stone River, 1, Friedland, 1, Eaton's, 1, 2, Fort Union, 1, which said persons, or a majority of them, after being bound by solemnity of an oath to do equal and impartial justice between all contending parties, according to the best of their skill and judgment, having due regard to the regulations of the land office herein established, shall be competent judges of the matter, and hearing the allegations of both parties and their witnesses as to the facts, alleged or otherwise, as to the truth of the case, shall have the power to decide the controversy and determine who is of right entitled to entry for such land so in dispute, when said determination or decision shall be forever binding and conclusive against the future claim of the party against whom such judgment shall be rendered. That is, that as often as the people in general are dissatisfied with the doings of the judges or triers so to be chosen, they may call a new election at any of the said stations and elect others to act in their stead, having due respect to the number now agreed to be elected at each station, which persons so to be chosen shall have the same power with those in whose room or place they are or may be chosen to act, that where any person shall remove to this country with the intent to become an inhabitant and depart this life either by violence in the natural or in the natural way, before he shall have performed the requisites necessary to obtain lands, the child or children of such deceased person shall be entitled in his or her room to such quantity of land as such person would have been entitled to in case he or she had lived to obtain grants in their own name. And if such death be occasioned by Indians, the said Henderson doth promise and agree that the child of children shall have as much as amounts to the head rights, gratis surveyors, and other incidental fees accepted. And whereas from our remote situation and want of proper offices for the administration of justice, no regular proceedings at law can be had for the punishment of offenses and attainment of right, it is therefore agreed that until we can be relieved by government from the many evils and inconveniences arising therefrom, the judges or triers to be appointed as before directed when qualified shall be and hereby declared a proper court of jurisdiction for the recovery of any debt or damages. That as the settlement is in its infancy, unknown to government, and not included within any county within North Carolina, the state to which it belongs, so as to derive the advantages of those wholesome and salutary laws for the protection and benefit of its citizens, we find ourselves constrained from necessity to adopt this temporary method of restraining the licentious and supplying by unanimous consent the blessings flowing from a just and equitable government, declaring and promising that no action or complaint shall be hereafter instituted or lodged in any court of record within this state or elsewhere for anything done or to be done in consequence of the proceedings of the said judges or general arbitrators, so to be chosen and established by this our occasion. The following are additional resolution and further association were also entered into at Nashboro this 13th day of May 1780, to wit, that all young men over the age of 16 years and able to perform military duty shall be considered as having full right to enter for and obtain lands in their own names, as if they were of full age, and if that case not be reckoned in the family of his father, mother, or master, so all as to avail them of any land on their account. Whereas the frequent and dangerous incursions of the Indians and almost daily massacre of some of our inhabitants renders it absolutely necessary for our safety and defense that due obedience be paid to our respective officers elected and to be elected at several stations or settlements to take command of the men or militia at the fort or station. It is lastly agreed and firmly resolved that a dutiful and humble address or petition be presented by some person or persons to be chosen by the inhabitants to the General Assembly, giving the fullest assurance of the fidelity and attachment to the interests of our country and obedience to the laws and constitution thereof, setting forth that we are confident our settlement is not within the boundary of any nation or tribe of Indians, as some of us know that and all believe that have fairly sold and received satisfaction for our land or territories whereon we reside, and therefore we hope we may not be considered as acting against the laws of our country or the mandates of governments, that we do not desire to be exempt from the ratable share of the public expense of the present war or other contingent charges of government, that we are from our remote situation utterly destitute of the benefit of the laws of our country and exposed to the depredations of the Indians without justifiable or effectual means of embodying our militia or defending ourselves against the hostile attempts of our enemy, praying and imploring that the immediate aid and protection of government by erecting a county to include our settlements, appointing proper officers for the discharge of public duty, taking into considerations our distressed situation with respect to the Indians, and granting such relief and assistance as in wisdom, justice, humanity may be thought reasonable. Nashboro, the 13th of May, 1780.